According to computer, it's 6:59.
Test, test, test.
It is 7 o'clock. It's 7 o'clock. I need to call this meeting to order. And I would like to invite Mr. Ross to join us to make sure that we have a quorum. So thank you for being here. All right. Then next on the agenda, before the approval of the agenda, is the organizational meeting. We need to elect a chair and a vice chair. And we can do that with a quorum regardless, right? And okay, good. So I would like to entertain a motion. I'd like to make a motion to re-elect Bert. Chair.
I'll second that.
Okay, all in favor, say aye.
Aye.
Thank you very much. I appreciate that. I would like to make a motion to reappoint Linda Brigardner as our vice chair.
Second that.
All in favor?
Aye.
That was unanimous. Next, before the agenda is the Town of Mills River meeting schedule. I'd like to entertain a motion to adopt that schedule.
I make a motion to adopt the schedule.
Second. All in favor?
Aye.
That's unanimous. Next, approval of the agenda. I'd like to entertain a motion.
Propose a motion to approve the agenda.
Second. All in favor?
Aye.
Agenda approved. Then we have minutes of our last meeting of October 14, 2025.
I make a motion to approve our minutes from October 14th, 2025.
Second. All in favor, aye?
Aye.
That was approved. Public comment. Anybody sign up? No. Thank you. New business. Board training videos. Quasi-judicial process and deciding quasi-judicial cases.
So the board chair requested we do a training since we've had some light agendas recently, and so this was a set of videos the town purchased to have access for a year from the UNC School of Government. Due to them being copyrighted, we can't broadcast them, although I may leave the audio on in case anyone wants to listen. But we'll go into that now. Thank you. Give me 1 second to transition.
And as you're pulling this up as a matter of order, I know there is some members that have to leave early. And you're excused whenever that time comes while there still is video.
Hi, I'm Jim Joyce, UNC School of Government. My area of focus is the land use and local government jurisdiction, which includes deciding quasi-judicial cases. That's what we're going to with this module. So this is the touchstone for deciding quasi-judicial cases. This is the statute 160D 406J, and it gets repeated whenever there is a case before the North Carolina Supreme Court or the North Carolina Court of Appeals about quasi-judicial decision making. As you can see, that is that every quasi-judicial decision must be based on competent, material, substantial evidence in the record. Talk about deciding quasi judicial cases. It's what we mean. We're talking about how we look at that competent material and substantial evidence in the record and the need to focus on that and not other choices. Material, substantial evidence. Well, we have this decision, North Carolina Court of Appeals that describes in a little more detail what one who is testifying from firsthand experience, for example. Or if we're talking about if someone is presenting an opinion, they're an expert. That's competence. Material evidence is evidence that has some connection. It is relevant to the decision that we're making and to the standards that we have to apply. Lastly, substantial evidence. The language of the case is that it consists of more than a mere scintilla, and such relevant evidence as a reasonable mind might accept as adequate to support the conclusion. Well, put it differently, substantial evidence doesn't mean piles and piles of uber convincing evidence. Substantial evidence means that the evidence that's presented has some substance to it. It tends to make it more likely that someone could find one way or the other in a quasi-judicial case. So competent material and substantial evidence is what we're looking for in the quasi-judicial hearing, and that's what needs to be the basis for the board's decision. Now, talk a little bit about witness testimony. Witnesses should be sworn. This may be done as individual witnesses come up. Some boards will even swear in everyone who wants to testify on the case at the beginning of the case. One way or another, however you do it, the witness has to be sworn in. And they have to be testifying to factual information, something that is supported by their firsthand knowledge or document evidence. And it needs to be focused on the standards that are being applied and the land use impacts of whatever is being proposed as part of the quasi-judicial decision. Very important to stay focused on those standards and the land use, and not the owner, the applicant, tenants, future residents, someone who's involved otherwise with the project. A special use permit, variance, any other quasi-judicial decision relates to a particular land use. This use on this property. The character of the owner or the history of the applicant, those aren't about the land use on the particular property. And so those are not to be part of, those are not statements that can be part of what the board uses as the basis for its decision. We can't stop anyone from providing different testimony, but the testimony that the board relies on needs to be factual and focused on the standards to be applied and the land use impacts of the proposed use. In addition, if we have someone who is presenting an opinion, I mentioned a moment ago, if we're talking about something that will happen in the future, that opinion needs to be given by an expert. This is different from legislative decision-making. When we have a text amendment or a rezoning, in that context, people might talk about
might talk about what they think is going to happen. But in a quasi judicial decision, that may have limited value in a legislative decision anyway. But in a quasi judicial decision, if I'm going to testify about what's going to happen with, say, traffic, property values, or other kind of technical matters, we need that opinion to come from an expert. Here's an important distinction. I can testify to what traffic is like on my street on an average day. I live there, see cars going by. I may or may not be able to I probably won't be able to give an accurate count, but I can give a general idea. I have I have firsthand knowledge of those facts, but I'm not a traffic engineer. And so I can't present my opinion about what's going to happen to traffic on my street if some quasi-judicial decision is made that allows a particular use, say in my neighborhood or next to it. That opinion has to come from an expert. One note about testimony. Boards can limit the amount of time that an individual might testify. Usually, it's okay to give a little more time to the applicant because they are the one who has the burden of proof, as we'll talk about shortly. But reasonable limits, fairly applied, can be put on the length of someone's testimony. It's often helpful to, maybe at the beginning of a quasi-judicial hearing, to remind the public that in a quasi-judicial case, we need facts. For those of you who are of my generation or before, we're like Joe Friday. We need you to give us just the facts, unless you're an expert. That's witness testimony. It has to be focused on the standards and the land use impacts as well. The other kind of testimony, the other kind of evidence that we may have in a quasi-judicial case is document evidence. This includes the application, staff reports, responses to requests for additional information, any documents that were submitted and distributed before the hearing, or documents that are presented at the hearing. I might have my 8x10 color glossy photos with circles and arrows and a paragraph on the back of each one that I pass up to members of the Board of Adjustment at the hearing. That's also document evidence that needs to be part of the record. There you have it, testimony and document evidence. Important to note that we also have to make any objections at the hearing. There's a party who wants to object to a particular piece of evidence, that objection needs to be made at the hearing. All right. So we've gotten all the evidence. We've collected competent material and substantial evidence. We've gotten firsthand knowledge. We have some expert opinion, perhaps. All of the documents that came forward in the case, whether before the hearing or during the hearing. Now it's time for the board to deliberate. And the board needs to do that in open session, even if it's uncomfortable. In North Carolina, we put a strong emphasis on government transparency, especially at the local level. And so deliberation about a particular quasi-judicial decision needs to happen while we're still in open session. There are only a few situations in which a board can go into a closed session, and those are almost never going to arise in a quasi-judicial case. The board also needs to be focusing on, just like the evidence, they need to be focused on the standards that are being applied in the quasi-judicial case. These are either the standards that are present in an ordinance relating to special use. Or they might be focusing on the 4 criteria that are in state law for granting a variance. In either case, we're focusing on the evidence and how that matches up with the standards. So in that deliberation, how do we decide who to vote for? Well, there are some clear rules about the burden of proof in a quasi-judicial case. And I like to think of it in terms of the scales of justice. I mean, you always have justice holding up this scale. At the beginning of the hearing, the scales of justice are tipped away from the applicant. The applicant has the first burden of proof. They need to provide competent, material, and substantial evidence that would tend to show that their application for a special use permit, variance, what have you, meets the criteria that are being applied. In legal terms, we call this making your prima facie case. If an applicant does not make their prima facie case, scales of justice remain tipped away from them, and they don't get whatever it was they're applying. However, the applicant provides, or someone on their behalf provides, competent, material, and substantial evidence that tends to support a finding that all of the standards to be applied are met, then the scales of justice tip the other way. If the applicant is the only party or the only person that presents competent, material, and substantial evidence, or if all the competent, material, and substantial evidence supports the applicant, then they are entitled to whatever quasi-judicial approval they were looking for. The board actually doesn't have the authority to deny a quasi-judicial application when the applicant has met the burden of proof, but there's no competent, material, and substantial evidence going the other way. Once the applicant makes their prima facie case, the scales of justice tip in their favor. If the opponents of whatever project is being considered, if the opponents of that special use approval then provide their own competent, material, and substantial evidence, well, now it's for the board to weigh the evidence and decide based on these contested facts, who has the better argument or who has the better evidence. So it's that scales of justice starting out opposed to the applicant, then they make their case and the scales of justice tip in their favor. And then when we put some more competent, material, and substantial evidence on the other side, now it's up to the board to weigh that evidence. In doing so, the board will then make a final decision to approve, deny, or approve the application with conditions. If the board does approve quasi-judicial application with conditions, those conditions should relate to the standards that are being applied and to the land use impacts of the proposed use. As you can see, for most quasi-judicial decisions, the board need only decide by a simple majority. You have 5 members on the board, just need 3 of them for a special use permit, an appeal of an administrative decision. But for variances and variances only, we need a 4/5 majority. So, gotten our evidence, board has considered it, they've deliberated, they've applied the appropriate burden of proof, and voted to approve with conditions, or deny the application. Now, it's time to reduce that decision to writing. There are different ways that one can do this in terms of the precise mechanics. What we need to end up with is a document that describes the board's findings of fact, how they applied the facts to their standards, and that describes any conditions that might have been put on an approval. It needs to accurately reflect the decision, the final action that the board took, and the reasoning that got them there. It also needs to be approved by the board and signed by the chair or another authorized member. Now, as I said, there are different ways to produce this written record. Some local governments might have forms or drafts that then are commented on and filled in by the board during the meeting. Others might just put something together after the meeting. Some boards even have in a separate meeting a vote to approve the written decision. Not necessarily required by the letter of the law, but as long as you've got that accurate record of what the facts were, how the board used those facts to get to their conclusion, and it's approved by the board and signed by the chair, then we have a solid quasi-judicial written decision. Now, why is that decision important? Part of the reason why it's important to have a good written decision is that parties withstanding who are aggrieved have a right to an appeal quasi-judicial decisions. Most of those appeals are going to go to superior court, right? They go to regular trial court. When it gets there, the court does not have its own evidentiary or factual hearing. It sits like an appellate court. In the Court of Appeals and the Supreme Court, we don't call witnesses and testify and have dramatic courtroom moments. It's two lawyers arguing their case. And so when a court is looking at a quasi-judicial decision, what they have to go on is the written record. They're going to look at that record for potential errors in applying the law, like violations of the Constitution, things like conditions that might exceed a local government's statutory authority, something that's inconsistent with applicable procedures that are in the statutes or their ordinance, and other legal errors in the decision. Now there, the court can second guess the board and kind of substitute their judgment. But courts also might review a quasi-judicial decision that has been appealed on the basis of whether there is support in the form of competent material and substantial evidence in the record for the decision the board had made. That decision is not supported by competent material and substantial evidence in the record. It might be what we call arbitrary and capricious. That's when we just kind of pick a result out of a hat. So it's important to have a good evidentiary record from your quasi-judicial decisions so that when and if quasi-judicial decision is challenged and goes to superior court, there's a record that accurately reflects the evidence that was provided and the reasoning that got the board to where they ended up. Now, talking about appeals, who has standing to appeal? Not everyone can appeal a quasi-judicial decision. The person has to have standing. They have to have a certain kind of stake in the final decision. Usually that means the property owner, right, of the property that's the subject of the quasi-judicial approval application, or the applicant. Those folks, if they don't get the result they want, and they feel that there's been some sort of error of law, or the board made a decision that wasn't grounded in the evidence, then they can appeal that to superior court. Fun fact, a governing board, that's your city council, your board of county commissioners, your board of village aldermen, that governing board of the elected officials can appeal a decision made by their own board of adjustment. It does happen sometimes. So the governing board is another party that has standing. And finally, other property owners who will suffer special damages. The law calls it suffering special damage. Now, people who suffer special damages are in a very narrow category. Most property owners, even those whose property might go down in value or who might be right next door to the property in question, they're not necessarily going to meet this criterion of suffering special damages. Special damages means it's unique to the property. For example, my house is on a hill and there's another property owner across the street and below me. If I were to apply for a special use permit to turn my house into a much bigger building, then for the most part, people around me, even in my neighborhood, are not going to suffer special damages. But if I'm going to be impacting stormwater flows and I'm going to be, say, trash is going to trickle down onto my downhill neighbor's property, then they're in a unique situation. And that means they would suffer special damages. So they would have standing to appeal a quasi-judicial decision in my favor. It really has to be a unique situation for someone to be suffering special damage. Couple of notes wrapping up on compiling the record. Again, that consists of the application, supporting materials, the record of the hearing itself. Now, usually you'll have an audio or video recording of the hearing. If not, then we need to have detailed minutes of the hearing, detailed enough that a court reviewing the record can follow what evidence was presented to the board, how they reacted to that evidence. And of course, any other documents that get submitted, that also becomes part of the record on appeal. And so then, again, a court reviewing that quasi-judicial decision is going to be looking at the evidence. Was there enough competent material and substantial evidence in the record? And what was the board thinking when they were trying to apply this evidence to the standards that are in the ordinance or in state law? So that is how we decide a quasi-judicial case. It all comes down to competent material and substantial evidence in the record.
It's back on. All right, so thanks for watching that. If it's the pleasure of the chair, in the interest of time, we'll skip over the next video, and I would just ask that if any Board of Adjustment members want to watch the video just on the quasi judicial process, just to reach out to me and we can make that work. I know we've reviewed that quite a few times. And so we're done with the training item. So I believe we usually try to put this before the board once a year during the organizational meeting, just as a refresher. I'm not going to go through it in any detail because I do remember we reviewed this through all the different articles and sections a year ago. Again, if anyone has questions, feel free to reach out. I think the only thing I wanted to highlight, which was also covered by the video, is just that because these are quasi-judicial court-like cases, board members need to be really careful about engaging with others outside of the evidentiary hearing. And standard practice or best practice, as Mr. Joyce from the School of Government said, is normally for folks to, again, not engage or discuss the application with others before the meeting. But there are allowances for that in some form. But our charter and rules of procedure for the Board of Adjustment is actually even more strict than that. And it actually states in Article 5, Section 2, conduct outside of the hearing, that due to the quasi judicial nature of the board members shall not discuss any case with or receive any information from any party or other interested person outside the hearing. So again, best practice is to follow this. There's some flexibility based on how other counties and cities operate, but just wanted to highlight our charter and rules of procedure is very black and white on this, that everything considered should happen in the evidentiary hearing with the applicant present, and that includes research and contacting other organizations and individuals. But if there's other questions about the charter and rules of procedure, just reach out to Patty or myself, and we'll get that to you.
I would say it's if it's unexcused.